This Council resumes the second reading debate on the Construction Industry Security of Payment Bill. Dr. III.Govt, Chairman of the Bills Committee on the bill, will first address the Council on the committee's work. Dr. III.Govt. President, as the Chairman of the Bills Committee on the Construction Industry Security of Payment Bill, I now report the highlights of our deliberations to the Council. The bill seeks to improve the payment terms of contract and provide an adjudication mechanism for quick resolution of payment disputes by an independent third party to improve the long-standing situation of delays in contractual payment among stakeholders in the supply chain of the construction industry. The Bills Committee held 11 meetings with the administration to scrutinize the bill. At one meeting, we received oral submissions from 50 deputations. Members of the BC generally supported the bill. They hoped the legislation would better protect industry stakeholders, receiving the pay they deserved for work carried out, so that the construction industry could develop in a healthy and sustainable manner. During the deliberations, members suggested expanding the bill's scope to cover more works, including the large-scale building maintenance works for private flats under Operation Building Bright 2.0. The administration responded by pointing out that the ultimate paying party of such project were owners' corporations or owners themselves who would struggle to meet the bill's requirements in practice. To avoid disruption for the public, the administration left these works out of the bill. On this matter, members urged the administration to review whether the future ordinance should cover those works after the ordinance was in operation for a while and experience was built up. The administration promised to remain open to views and review the matter when appropriate. The bill gave the claiming party the right to suspend or slow down their work or service upon meeting certain conditions. This led to members' concerns over whether the measure could deal with disputes over outstanding final payments effectively. The claiming party, in such a case, would have completed the work under the contract. Given this, members argued suspending or slowing down work would do nothing to pressure the paying party into settling the amount. There were calls for a time limit on account settlement. The administration replied that the bill could facilitate early resolution of mid-contract disputes between parties. This could improve the cash flow of stakeholders in the supply chain and reduce the time needed for account settlement, to which the bill applied. If the amount claimed at this stage involved the claim handling procedure under a contract, the bill also set out a mechanism requiring this procedure to be completed in a reasonable time. Members pointed out that while workers earned less by suspending work, lower-tier parties would also see their work progress hampered by claiming parties exercising such a right. Therefore, members raised the concern over whether the administration would take measures to protect workers. The administration explained that the bill recommended giving at least 5 days' notice to the paying party and project owner if the claiming party sought to exercise their right to suspend or slow down work or service. Doing this would help remind the paying party to fulfill their responsibilities swiftly and prompt the project owner to step in early if need be to resolve the payment dispute. This way, the works could carry on while workers could keep working and getting paid. Some members wondered whether a payment dispute involving purely oral contract would make it hard for an adjudicator to reach a determination. Besides, in the construction industry, wages may be paid in 2 unequal batches, possibly based on oral contract without any written record. Given this, the administration was asked how it planned to address wage arrears involving such 2-batch wages. On this point, members proposed a greater government effort to encourage written contract for works in the industry and among stakeholders to give parties stronger protection. The administration explained that the bill mainly aimed to address disputes between contractual parties so that subcontractors receiving the payment they deserved became less likely to leave workers unpaid. Handling different forms of contract, including oral contract, would be covered by government guidelines to be given to adjudicators. The administration reiterated that the bill was not about dealing with wage arrears of workers. Whatever the statutory rights under the bill, the main contractor and their subcontractors must meet their obligation to resolve wage disputes under the Employment Ordinance. The rights and interests of construction workers under the EO and the protection of wages and insolvency fund would remain unaffected under this bill. The BC noted the ban under the bill on conditional payment contractual terms, such as pay when paid terms. Members raised the concern that stakeholders may struggle to cope with the financial strain caused by this bill's passage given the sluggish economy in recent years. Therefore, some members suggested making an exception for non-payment when an upper-tier party went bankrupt in the chain. In this case, pay-when-paid terms should be allowed to prevent a knock-on effect on lower-tier parties. The administration saw this idea as against the basic principle of the bill to make sure stakeholders receive the payment they deserved after completing the contractually required work. During the consultation on this proposal, most industry stakeholders also opposed granting an exception for the bankruptcy of an upper-tier party. The bill set out the functions of adjudicator nominating bodies as including the making of adjudicating rules, practice notes, and codes of conduct for adjudicators. Members wondered how the administration could ensure consistency and effectiveness across these notes and codes from different ANBs. The administration clarified that the Development Bureau would draw up the main content of the adjudicating rules, practice notes, and codes of conduct, while the ANBs could add other details approved by the Secretary for Development to meet their respective operational needs and requirements in professional ethics. This would ensure consistency in adjudications involving different professional bodies. In response to views from the BC, the administration would move amendments to better reflect how those provisions would work in practice. Members also wondered what measures would be taken by the administration to guard against a potential conflict of interest of an adjudicator appointed for a case. The administration replied that an adjudicator candidate must declare and disclose any conflict of interest to their ANB, which must then forward the information to the parties and consider their views before appointing a suitable adjudicator. Besides, the administration would follow the guidelines on conflicts of interest in international arbitration drawn up by the International Bar Association in devising a set of standard guidelines on conflicts of interest for adjudications. On publicity and public education, members suggested compiling frequently asked questions about the practical details of the future ordinance and preparing clear guidelines for the industry to get a better sense of how the ordinance would work in practice. The administration pledged to remain in touch with the industry and consider members' views to get it right with the bill's details as well as publicity and education efforts. Madam Deputy, here are my thoughts on this bill. Subcontracting is commonplace in the local construction industry. This is not about any particular person. This is about how the industry works. The practice came into existence over time. The construction sector covers a wide range of works: site formation, infrastructure, building. Many stakeholders are involved. Project owners, contractors, subcontractors, works consultants, suppliers, and construction workers. Works project cover a wide range of steps and expertise. Each project is unique. No single contractor can undertake an entire project based on their own resources. Flexibility is also needed in procuring. That's why subcontracting is so common in the industry. There are stakeholders in the supply chain. They have to use their own resources to start a project. And then based on the progress and the contractual terms, the subcontractors recover the fees, expenses for the equipment and works. Large amounts are often involved. Ensuring a healthy cash flow is crucial to stakeholders. Subcontracting is a tried and tested method in the industry. As with any other mechanism, there may be flaws. Some stakeholders are troubled by payment issues. A paying party fails to pay or delays in paying. Each step is interrelated in the industry. When one party fails to pay, there are knock-on effects. Contractual terms are in place. This means a party owed fees have to pay out of their own pocket to keep the project going, and that brings risks. For less resilient small and medium businesses, they are hit particularly hard. Payment issues also give rise to other problems. Project delays, for example, wages who owe their wages. That's why there are calls in the industry for such a bill and set up a mechanism to resolve payment disputes quickly. This is to ensure the smooth progression of construction project and also ease the trouble for many stakeholders. The 2024 policy address proposed 8 measures to support SMEs. One of them is this bill to offer better protection for payment in the construction industry. This is a welcome step because it responds to the community's cause. The problem about payment in the construction industry is not unique to Hong Kong. In Singapore, Canada, and the UK, they also have legislation in place. Our own bill is drawn on not just overseas legislation, but also the views of local stakeholders. During our deliberations at the BC, some members argued when an upper-tier party went bust and could not pay, what we could do to prevent a knock-on effect on lower-tier parties. At that meeting, I followed up on the matter. A complex, large-scale project may involve an upper-tier party going bust, and then you may have a domino effect. With or without this bill, the problem is there. In a bankruptcy, their different creditors get their money back in different orders. There are rules in place. The concern remained that when one party goes bust, the chain is snapped. The flow of money also snaps. The Development Bureau has experience in this matter. The Bureau can do something to meet the cause of the industry. For example, for this future ordinance, for the lower tier parties, help can be given so that these parties get their money sooner. I'm from the engineering sector. The fact that this sector has a place in electrical shows the community recognizes the role and contribution of the industry. The construction industry is a key player in the community. Works projects cover transport, hospital building, schools, and other facilities serving the public. The sector drives the economy and improves people's lives. The sector has almost 400,000 workers and provides livelihoods for many families. This bill ensures the smooth operation of the industry in terms of the cash flow and supply chain for different stakeholders to get paid for the work they do and share in the success of the economy. This bill will foster the sustainable development of the sector and also contributes to social cohesion. The government should not only work with the industry to promote the bill so that stakeholders know their rights and duties, but also keep an eye on the details. Other issues may come up. On that, the government should work with the industry to sort them out, and this means timely review and amending the law. Madam Deputy, I so submit. I support the passage of the Construction Industry Security of Payment Bill and the amendments to be moved by the Secretary for Development. Mr. Andrew Lam. Madam Deputy, payment disputes arise between upper-tier and lower-tier parties. That's common in the construction industry. You find out more about the culture about this issue, and you will see why. And that has to do with the cash flow. Subcontracting is commonplace in construction. Many people are involved. When one party delays in paying, everyone else's finances are affected, and they may not be able to deliver on time. SMEs are less resilient, and they are hit particularly hard. To drive a change to a long-standing practice is not easy. It took the industry a long time to come to this stage with this bill. To ensure stability, the Development Bureau took on this tough task, and now we're taking this vital step. But that is not to say this bill will be a silver bullet. The bill seeks to improve the long-standing situation of delays in payment. This is about protecting everyone in the supply chain. We want people to get paid for getting work done so that the construction industry can develop in a sustainable and healthy way. And this means improving contractual payment terms and setting up an adjudication mechanism when a payment dispute arises. When that happens, we resolve it quickly. But it's up to the parties whether to turn to adjudication. After an adjudication, when the payment is still outstanding, the claiming party can suspend work. I was a member of the BC. I knew the complexity of the bill. The provisions are complicated, and it will even get more so by the time we get to operation. People wonder if the bill's passage will lead to higher costs and whether there will be a domino effect where subcontractors fold. So, in the early days, the government must keep an eye on the market. On awareness of the bill and the future ordinance, the government must explain to stakeholders how the law works. Driving a cultural change is the hardest part. During the deliberations, I said this. There were things the government needed to be mindful of. One, oral contract. It's an honor system. Disputes can arise. So I call on the government to step up promotion. Let's encourage written records to protect everyone's rights. Contracts cover many matters, including judgments made by professionals. You cannot spell everything out in the bill. The government promised to come up with guidelines for adjudicators. The government needs to show people how this law will work, how disputes are raised, and then we use that information from cases handled for publicity. Clause 63 has to do with the functions of adjudicator nominating bodies and also the powers of the Secretary for Development. The government took on board the BC's views. This means the Secretary can issue suitable guidelines to A and Bs. And this means offering guidelines on the making of adjudication rules, practice notes, and codes of conduct. That is to cope with different problems that may arise and make changes where needed. Delays in payment are common in the construction industry. The global economy is slowing down. Cash flow problems can come up. Small, medium, and micro businesses are struggling. The bill is about dealing with the payment issues in a construction industry that sees subcontracting everywhere. This is about providing better safeguards. During the BC's deliberations, I reminded the government to set a good example. I want to thank Dr. Lo Wai-kwok, the chairman, and the deputy chairman, Mr. Chen Shu-hong, for leading the work. I also thank the government and the secretariat for helping us navigate this complex bill so that we could get through the bill efficiently. This is a vital step we're taking. For the government, once this bill is passed, please keep an eye on the market situation to make sure the bill and the future law works as intended. I so submit I support this bill. Mr. Edward Lau. Thank you. I support the Construction Industry Security of Payment Bill. This bill will make sure workers who put in the work will get paid on time. This is a step to change the culture in the construction sector, and this can project a more positive image of the industry. Wage arrears are common. When the main contractor fails to pay on time, the subcontractors still have to work, and that's why workers have to work without getting paid. The bill today is that when a payment claim is filed within a certain number of days, the payment has to be made, and then there is also a mechanism to hand down determinations that are binding. I support this. The first such proposal was consulted on in 2015. Many stakeholders are involved in the construction industry. There are different views. I thank Ms. Bernadette Lin and also Mr. Ricky Lau and also the entire team of the Bureau for overcoming so many obstacles, forging a consensus with the industry, and coming up with this bill. This bill can help address the delays in payment in the industry, and this can better protect workers and improve the image of the industry. In the years to come, we will see many works projects. This bill will mitigate the delays in payment so that workers can get paid. When there are risks of delays in payment, subcontractors factor in the risks. And now with this bill, they will see greater certainty. I look forward to the bill's early passage so that we can cover not just public but also private contracts. Last November, this bill was first announced along with the adjudication mechanism. We had a discussion. I wanted to see the early passage and also wanted to compress the time it would take for the adjudication. I welcome the adoption of these suggestions from me. Now the adjudication would take 3 months instead. The main provisions will be taking effect 8 months from passage instead of 1 year. This shows the Bureau has been responsive by coming back with an amended proposal. Moving faster will be helpful for the industry. The lower tier parties in a project have to pay out of their own pocket to keep the works going. They can make it work for 1 or 2 months. And they may even have to sell their own properties if it gets longer. This bill will ban the conditional payment terms. That makes sense. When parties do the work and then an upper tier party fails to pay, that's not fair to these lower parties. So now this bill will offer protection. The bill also sets out the right to suspend or slow down work. When an upper tier party fails to pay, and then the lower party can give 5 days of notice to the paying party and the project owner, and then this party can exercise the right. This won't be treated as a breach of contract. The bill also says that the claiming party has to resume work within days of getting the payment. This arrangement can ensure timely payment and also the resumption of work once the payment goes through. 6 days is the time limit on payment. An adjudication has to start within 28 days of the initiation. So the whole process takes 3 months. And then the claiming party can apply to a court for an enforcement application. Parties not happy with the determination can also refer the case to a court. This bill sets out a clear adjudication mechanism. Disputes can be resolved. The claiming party will now see greater certainty. An adjudicator will apportion the fees so that the lower party can look at their situation in deciding whether to start an adjudication. This guards against abuse. The bill will mainly cover public contract. For private contracts, though, we still need a timetable. Once this bill comes into operation, I hope the government can do something about that. The bill will help drive a cultural shift. It's a first step. There are long-standing practices in the industry. We cannot hope to get rid of all of them with one step. Now, here are some ideas for the government to consider. Subcontracting has been in place for a long time in the industry, but is that the best way? Should we stop at a certain point in subcontracting? Having excessive layers of subcontracting is not healthy. I just noticed something in the market. The main contractor finds a subcontractor, but the money doesn't change hands. The subcontractor gets the contract. But the subcontractor is not licensed. They simply hand out the contract to a licensed subcontractor. And this creates risks as to whether the project can be completed on time. So that's something that warrants the government's attention. Sometimes you need a gentleman's agreement, but in the industry, there's asymmetry in the bargaining powers between main contractors and subcontractors. Sure, we will have the law, but In this industry, there are injustices. Some subcontractors have to bite the bullet. They have to grin and bear it. So, for the government, the task is to make sure subcontractors are protected despite being in a weaker bargaining position. I support the bill, and I hope the bill can be passed and implemented. Here, I want to thank the Bills Committee, Dr. Low Kwok, the chairman, and Mr. Chen Xiu-hong, the deputy chairman, and all other members for their work. I also thank the Development Bureau for being responsive. I welcome the amendments, so now we get a better and more practical bill. I support the bill and call on members to support this bill's early passage. Thank you.
Mr. Chen Xiu-hong. Deputy President, I speak in support of the Construction Industry Security of Payment Bill. I support the second and third readings. The bill seeks to transform the prevailing payment delays practice in the construction industry. Now, in the Development Bureau conducted study in 2011 and 2023 on the payment practices of the industry. They find that contractors, subcontractors, work consultants, or suppliers face problems of outstanding payments, and these outstanding payments account for 5 to 12% of their total business receipts in a year. And then the study also find that there's long delays, and so the reasons are found out, and then there is a proposal to change the practice in three ways. One, First, there is measures to facilitate the recovery of payments on those construction contracts, and then there is also a speedy resolution mechanism of the payment disputes. And then a right will be given to the paying part to the claiming party for suspending or reducing the rate of progress of works or supply of goods and services under the contract when there's a payment delay. So these proposals will improve the situation of payment delays in the industry. And if there is a higher layer of party that goes bankrupt, then other parties should not be owed payment. And then some are worried that if one party is bankrupt, then others may they may have difficulty paying the payment for other parties, or if one party is bankrupt, there may be knock-on effect on other parties. Now, at the Bills Committee, I expressed my views. I support the bill. I understand this bill cannot be ultimate solution to all the problems, but I just hope that the government wouldn't turn a blind eye to other issues. Now, after the commencement of the bill, the bureau, the administration to consider whether there's need to include exemption clauses, or maybe there should be a separate mechanism to handle bankruptcy cases. And then there must be measures to support the sector. For example, if there are adjudication determinations, then how can we help the claiming parties to recover the cost, the payment? Now, at the meetings, we discussed the policy issues. We asked the government that whether large-scale maintenance works under the Operation Building Bright 2.0 will be included in the scope of the bill. The government explained that there is a stringent time requirement for the adjudication process, and in maintenance works, the paying party is either the owner corporation or the owner, and there may be difficulties in complying with the stringent time frame. So if we don't include such works in the bill, I could understand that. There are media reports that there may be major disputes among owners on maintenance works, and there's a need to call owners meetings to vote on the matter, and then it's a lengthy process. And then owners may also not be familiar with may not have the necessary legal knowledge. If we include large-scale maintenance works in the scope of this bill, then there will be additional duties imposed on owners, and then owners may be reluctant to carry out maintenance works because they don't want to be caught by the law. And so that means there could be even more buildings in disrepair. But then, of course, it's true too that some maintenance works could be could cost as much as $100 million. So I would suggest that the government first accrue experience, and then the government could then consult the owners, corporations, and managing companies to see whether the scope of the bill should be extended to cover large-scale maintenance works, or maybe there could be a separate mechanism. So for private maintenance works, they will be given protection under the bill as well. Now there may be various scenarios in payment, and what about the higher layer contractor delaying payment to those downstream, so especially the final amount. So because it's already final amount, that means the claiming party cannot put pressure on the paying party by, say, slowing the progress of works. But then maybe sometimes the cost involved may even be additional works or alteration of order. So there could be disputes, and so now there could be delay in payment by several years, and it will affect the cash flow of the claiming party. So if works contracts involves additional amount, and there should be claiming process for such additional amount, and if and then the process must be followed, and if the process is not followed within the required time frame, then if the process is unduly long, then the claiming party could seek adjudication. Now, the adjudication mechanism will allow the referent parties to resolve payment disputes arising from the contract, and that will help to shorten the time for settlement of payment. But what is the reasonable time frame, though? I think I'm a bit concerned about that. And then there are other factors that may lead to the complexity of calculating additional amounts. So after the commencement of the ordinance, for some time the government should review the situation. And sometimes there's delay in payments not because the entire outstanding amount involves a dispute. I think we should ask the paying party to pay the part of the cost where there's no dispute. Now, on the adjudication process, the actual operation and the details are not set out in the bill. So when the government formulates the relevant code of practice and education rules and so on, there should be the examples to explain certain terms, so that there are specific terms, wordings used. For example, in clause 23 of the bill, there's the term reasonable time frame for adjudication. So what is reasonable? And then there could also be examples for offsetting on no offsetting of payment and so on. This is for the reference of the industry. Now, when the paying party has the right to delay, to slow down works as a means to put pressure on the claiming on the paying party. But then sometimes, as long as payment is not made, there are cases and works are immediately stopped. So there's a need to do more publicity and education on the bill. There should be FAQs, for instance. And there should be also illustrations by examples to explain the various scenarios, and then we could better explain the objectives of the bill and how it applies under different scenarios to the industry. And then clause 4(3), in Schedule 3, that is nominating. Now there's the telecommunications service providers should also be included in Schedule 3 as specified entities. So that's what I proposed at the Bills Committee meeting, and I'm glad that the Bureau has taken aboard my views, and they will propose amendment to Schedule 3 to include major telecommunications service providers as specified entities. Now, finally, I thank Dr. Low-Kwok for leading members in scrutinizing the bill, and also thank the administration for their efficient response and also taking on board our views. I thank the deputations too for their submissions. So I speak. Mr. Lam Chen Sing, thank you. Now, we find that construction workers often put up banners to say that they have toll, but they're not paid, so they try to pursue outstanding wages. Now, very often these cases are staged by contractors because subcontractors cannot receive payments from the upper layer of subcontractors, so they therefore ask reporters to come and see how construction workers try to pursue outstanding wages. This is to force the paying party to pay the outstanding payment. Now, delay in payments already the unspoken rule in the industry. It seems it's already taken for granted that there will always be delay of payment. In some cases, the payment can never be recovered. Now, the proposal has been in consideration for some 10 years, and finally we've come to the resumption of the second reading of this bill. I thank the Bureau for their effort. Now, on the scope of the bill, the payment protection security payment security mechanism applies to different types of works, and the value must be no less than $5 million, and that's for the main contract value. And once the main contract is covered, then all subcontracts are covered by the bill. But then for non-domestic construction works where there's no need to seek plan approval, they are accepted because the Bureau believes that these works are relatively straightforward. I don't agree. For example, refurbishment of restaurants or major shopping malls, they don't need to seek plan approval, but then the works may cost more than $10 million. And we have dealt with wage disputes in such contracts. There are medium-sized subcontractors who suffer delay in payments. So for such non-domestic works where there's no need for plan approval, the government should pay attention to these cases. If there are still payment disputes, and then eventually the government should consider including them into the scope of protection. So I propose that after 2 years of the commencement of the ordinance, the Bureau should review what works should be added to the scope. Now, sometimes when in the past, when subcontractors are owed payment, they still carry out the works because they are afraid they'll be sued. At the end, they don't get a dime at all. So now they have to pay when paid or arrangement now, and then subcontractors. Now the bill gives the rights to subcontractors to slow down the progress of work. I support that. But then the bill requires that within 60 days of the contract, the payment must be made. And if then payment dispute arises, then the claiming party needs to spend 28 days to prepare the application and then make the application, and then afterwards there will be a 62 days education process. Adjudicators will have to determine the amount, and then after that the payment party has another 30 days to make the payment. That means from the original date of payment until the claiming party can exercise the right to stop works, we're talking about 6 months. And in that 6 months, the subcontractor doesn't get payment. They have to maintain their works on site, and they have to pay the workers. They pay for materials and other costs. And then maybe while they wait, they go bust, and then workers suffer as well. So after the adjudication system is well established, then if we think that the respondent is being unreasonable, for example, it deliberately delays payment, it refuses to pay without valid reasons, or it abuses processes to delay the adjudication, then the claim party should be allowed to stop works earlier. This will reduce the loss of the subcontractor and workers. And then on the implementation details of the adjudication mechanism. Now, the bill only provides a framework for the adjudication mechanism, and then we have to wait for the relevant codes of conduct, practice notes, and education rules to be made for the details to be worked out. But my concern is that when will now, what if one party refuses to pay the relevant costs to the adjudicators, and then what measures should the nominating body take to make sure that the adjudication process is not affected? And then now the Bureau proposes that the nominating body will handle complaints against adjudicators. If individuals are not happy with the determination of the adjudication, what is the appeal procedure? And then if after appointing an adjudicator, one party questions the eligibility of the adjudicator, and then the adjudicator does not accept that query, then how will the nominating body handle the matter and to ensure the fairness of adjudication? Now, it said that the Secretary will provide will provide some templates that the nominating body should follow, and I hope there will be better explanation so we know exactly how the adjudication mechanism works, and then people with more confidence. Now, there is recognition of written and verbal contracts, but I'm worried that verbal contracts cannot be handled really, because I've dealt with many cases. Dump truck drivers who work as individuals, they only receive verbal notice to work on construction sites, and even if there's adjudication, they worry they're not able to recover their fees. So we should try to promote the use of written contracts. Now, the passage of the bill doesn't mean there will no longer be default in payment of wages in the industry. Now, we're talking about a cash flow of different stakeholders. That's what the bill handles. But then the bill does not really deal with the payment of wages and other relationship between the employers and the workers. And even if a subcontractor is able to recover payment from another contractor, it doesn't mean that they will then pay the workers. So now the employment ordinance stipulates that the employers must pay wages within 7 days after the work period. But then in the construction industry, delay in payment of wages is already a norm. So, and then workers dare not pursue wages because they will be threatened that they won't get any more work. So they will just put up with that. So how do we change this culture? I think the Development Bureau, the Labor and Welfare Bureau, and the whole construction industry still have a long way to go. I hope this bill will just present the opportunity and for us to address the structural problems in the construction industry, and then we can promote the healthy development of the industry. I speak in support of the bill.
Mr. Kwok Wai-keung. Thank you, Deputy President. There's a saying, one does not bear the fruit if they do not work. In fact, that was included in the national constitution. For people in Hong Kong, even though they have worked, they may not get paid. We had Feng Cheng K winding up. We have also recently another construction firm that is closing down. The FTU is very concerned about employee rights, even though in Chapter 57, 43C, that is the employment ordinance, said main contractors have the obligation to pay wages in arrears of workers of subcontractors, but this is not exactly implemented. That is, if practicable, main contractors should help recover payments. Now we are at this final stage of this bill that should provide more security for payment in the industry. So I support the bill. The bill would remove unfair terms from contracts, including pay when paid clauses. This is a practice that is deep-rooted in the industry. Even though work has been undertaken by the subcontractors or subcontractors, it is only when subcontractors are paid the subcontractors will be paid. Or in another case that subcontractors have already been paid, but it does not say in the contract the specific payment terms. The subcontractors would make up excuses to delay payment to subcontractors or have fragmented payments so that the subcontractors do not really get paid for the work they have done, and due to insufficient bargaining power, they do not really have any say in this because they are afraid that they may not get additional work for them speaking up. In many industries, oral agreements are used, and especially in the construction industry for various trades, oral agreements are used, and it would be harder to recover payment in such cases. What is going to happen then? The costs of the risks would be included in the subcontracts. That would raise the prices for the works. In clause 47 of the bill, it says that once the bill is passed, any payment terms in the contract could not include pay when paid clauses, or even if they are included, they would be rendered invalid. I do agree with this. But even with this provision, if the claiming part or the paying parties refuse to pay, what is going to happen? We have now an adjudication mechanism introduced in the bill. Should there be disputes, an adjudication proceeding may be initiated and a third party can make a ruling. If the adjudicator said the paying party must pay, and then within 30 days, the paying party must pay the claiming party. The role of adjudicators is very important. They must have integrity, they must be professional, they must have the relevant expertise. So I have talked about during the deliberations of the Bills Committee whether we have any way of vetting the qualifications and any interests to be declared for the adjudicators. So we are adopting an honor system, but if something happens, what are we going to do? The government said they would address this issue in the education rules, and we should have the details later. As for the training hours and training curriculum for educators, I understand that the nominating bodies are professional bodies. And we, of course, do not want people to use the education mechanism extensively. We need to make sure the mechanism is professional. The government said, again, in the education rules, we will have more details about the training contents and hours for educators, and I look forward to learning more about that. In clauses 58 and 59 of the bill, it says specifically that if claiming parties do not receive the payments that they are entitled to, they may suspend works. I again support this. For many projects, they are, of course, have a very tight timeline, and They would also have a punishment or penalty clause for subcontractors that do not complete the works in time. So that should prompt the paying parties to pay up on time. But let me say this here. Excuse me. Well, I've already talked about this actually. There is some sort of protection offered by the bill in relation to the suspension of works. Even if they are suspending works, they would not be regarded as not carrying out the obligation under the contract, and they would not have to compensate the losses suffered by the paying parties because of the suspension of works. Also, they can ask the paying parties to pay them for the costs that are reasonably incurred due to the suspension or delaying of the carrying out of works. Now, I'm most concerned about whether workers are paid if works are suspended. Workers may have the obligation to continue to work for this project, but if works are to be suspended, they are just on standby. Will they still be paid? This was also discussed during the deliberations of the Bills Committee. The administration said they would think about this. I want to say this in particular. This should offer more flexibility for claiming parties to allow workers to work in other construction sites for the time being when works are being suspended. I also hope the bill will be passed today to protect workers' interests. And I also hope that through this bill, not as many subcontractors will go bust due to cash flow problems. And it will also improve the environment of the industry so as to attract more new blood to join the industry. Thank you. Mr. Tony Tse. President, we are resuming second reading debate on the construction industry security of payment bill. This has been discussed in the industry for a long time. The starting point was the 2009 Asian financial crisis. During that time, many firms faced cash flow problems and there was a prevalent delay in payment. Workers worked but they were not paid. We were asked to follow the practices of the UK, Australia, and Singapore to put in place legislation to ensure security of payment. In October 2012, the Development Bureau set up a working group to research into legislation. And in December 2021, in fact, that was the first month that I swore in as a LegCo member. When the bill received first reading in May of this year, the bill is set to resolve the long-standing issues of delayed payment in the construction industry, and it would also prevent unfair clauses from being incorporating into construction contracts. It will also provide for a mechanism for speedy resolution of payment disputes. It will also give a right to a party to a construction contract to suspend or delay the carrying out of works. I support the overarching principle, and the industry also supports it as well. But with the implementation and the details of the bill, there are differing opinions. Some of the provisions of the bill relate to how there should not be pay when paid clauses or conditional payment clauses in construction contracts. With these clauses, often the paying parties would make up excuses not to pay the claiming parties, And in fact, if they have the upper tier parties just close down without prior notice, the downstream parties may indeed suffer. But now we have an adjudication mechanism in the bill, and we have provided claiming parties the right to suspend or delay the carrying out of works. Some are concerned that it may make it harder for firms to carry out works. If for a certain reason a firm goes bust, and if this case goes into adjudication, will that cause a domino effect with multiple firms closing down? If that is the case, we would have a widespread delay of various projects. We may even have more workers that will not be paid. That goes against the legislative intent. In Ireland's security of payment system, there are specific provisions on this. If there are paid when paid clauses incorporated, when there is a company going bust, pay when paid clauses can be accepted. But then the government said this should not be dealt with in this bill. Some in the industry expressed their disappointment in relation to this. I urge the government to take a proactive approach. Under these circumstances, the government should provide appropriate support to alleviate the burden on the relevant stakeholders. If the paying parties do not make payment in accordance with the relevant procedures, the claiming parties may suspend or delay the carrying out of works with prior notice. It would also prompt the owners to take action to make the paying parties pay and resume works. But some in the industry are concerned that there may be an abuse of this mechanism. If one does not have enough workers, materials, or poor quality of works, when they are lagging behind in the progress of works, they would initiate the proceedings so as to shirk the responsibility or transfer the responsibility to others. The government said they would promulgate adjudication rules to prevent abuse of the mechanism, including asking the party that does not have reasonable justifications for initiating proceedings to pay the relevant costs. Some are also concerned about the expertise of adjudicators, whether they have the right qualifications and experience to make rulings. And I will talk about my stance in detail when we get to the CSA stage. The government may have addressed some of the concerns of the industry. There are some concerns that remain unresolved, but I still support the bill because the bill would resolve the deep-rooted issues in the industry to resolve the delay payment issue. However, we have seen with the experience of amending the OSH occupational safety and health legislation may not be the only means that is needed to change the culture. It is more important to actually change the habits of those in the industry, and the government needs to provide appropriate support. With delayed payment, the government should lead by example and settle payments on time. In fact, many in the industry said for many government projects, there has often been delay in payment because with the inspection and payment procedures being quite complex. After works are undertaken, those in the industry have to wait for a few months or even longer for the relevant departments to settle payment. So subcontractors and consultant firms are faced with much difficulty. They are put in a position where they would have cash flow problems. In the current economic situation, this is not ideal. I urge the government to do something about this. During the pandemic, I urge the government to provide more funds in advance to companies. I did see the Development Bureau doing that, but other departments or public bodies did not follow suit, or the management did make such directions. Those in the front line did not follow. They did not implement such expeditiously. They took their time, so we did not achieve the intended effect. I urge the Secretary for Development to encourage the other departments, including the Treasury, as well as the public bodies, to expedite the payment process. And this will act as an example for the private sector. Apart from the payment process improvements, the government has also made improvements to the procurement and tendering systems so that we will not only have the lowest bidder wins. We have more businesses closing down, going into liquidation. I think that has something to do with the cutthroat competition during the pandemic. We had many unusually low bids. We do not have a good economic situation right now, so we may see the same thing happening again. I urge the government to give more chances to small and medium-sized firms. We shouldn't concentrate our projects on certain firms undertaking works. I think the government should not slow down with the taking forward of infrastructure projects due to its tight fiscal position, because it may bring about disastrous consequences for the industry. Thank you.
Mr. Louis Long. President, a major proposal under this bill, the Construction Industry Security of Payment Bill, is to set up the adjudication mechanism involving an independent third party who will quickly resolve the payment disputes. That's to make it easier to recover payments. Subcontracting is a long-standing practice in the construction sector. From the project owner all the way down to the subcontractors and project consultants and suppliers, there are many layers of subcontractors. Lower tier parties usually have to start the works with their own resources, and then based on the progress and the contractual terms, these parties recover the money from the upper tier parties. This means a robust cash flow is crucial to the entire industry. When delay happens with one party, it's not just about affecting one business. The entire industry is affected. That's why the industry and I hope that this legislation can offer protection. I thank the Development Bureau for its sustained effort in talking to the industry. The bill is not perfect, but many industry stakeholders support this bill. They believe the bill should be endorsed soon, and that includes the 50 deputations at the public hearing. They support the bill's provisions. With the bill's enactment, there will be protection for payment, and there will be a better business environment. The bill sets out an adjudication mechanism. When a party does not get the payment, or when a party refuses to pay, the mechanism is there to settle the payment dispute. Adjudication is faster in resolving a dispute, and this can ensure the cash flow remains healthy. The adjudicator will play a key role in the process. That's why the appointment, resignation, role, functions of an adjudicator, as well as the effect of a determination, were the subject of many of our questions and suggestions to ensure fairness and transparency. Consistency matters across adjudicator nominating bodies. I hope that for the adjudicating rules, codes of conduct, and also practice notes can be put in place. With the guidance of the requirements from the government, those A and Bs can make their rules accordingly. One of the amendments is for the Secretary for Development to issue guidelines to A and Bs, especially about the adjudicating rules, practice notes, and codes of conduct. This amendment will be able to fill the gaps. This will make the mechanism more credible. I support this. Disputes over extensions of time tend to be more complex. I thank the government for adopting the industry's views by taking a phased approach. So for private works involving extensions of time or EOT, this ordinance will not apply immediately. Instead, public contracts will be covered first. This phased approach will give the government time to assess how the ordinance works, and then based on that experience, the government can improve the mechanism, and then the mechanism can be extended to private works. That's the prudent approach. The ordinance will take effect 8 months after it's published in the Gazette. I call on the government to make good use of the 8 months. This means we need clear guidelines for the industry so that they know how the law will work. Some professional bodies have started revising their standard works contract for the industry's reference. Adjudication is so important, and it takes time to train adjudicators. So the government can work with these professional bodies. Let's do workshops. Or we can look at past cases involving payment disputes. And let's have adjudicators try. Let's see how they will deal with those cases as part of their training, so that they get prepared for adjudication. The government should work closely with the industry and then review how the law works and then improve the details. The industry and I hope that this new law will offer better protection so that parties in the industry can get paid on time. With better cash flow, employers will be in a better position to pay their workers on time. Construction industry security of payment is not about protecting the wages of workers. This bill, once enacted, is about dealing with contractual parties, construction workers, are just like other workers. Their rights are protected by the Employment Ordinance, and that includes wage arrears. To make sure construction workers get paid for their work, the government must make a greater effort to tell construction workers how better to stand up for their rights under the EO. There will be a number of amendments in response to concerns raised by the Bills Committee to improve clarity and make the clauses easier to follow. I support those amendments. I support this bill and the amendments to be moved. Professor Chow Man Kong. President, the Construction Industry Security of Payment Bill will improve the situation where workers don't get paid for the work they do. This bill will cover public contracts. This is addressing a long-standing problem in the industry. This proposal is timely. Hong Kong will see many infrastructure projects. This bill will foster the healthy development of the construction industry. The current term government focuses on land creation and building homes. The Northern Metropolis project will start soon. Last year, the major transport infrastructure development blueprint came out. That blueprint set out the road and railway networks. And then there are many other projects, such as the public hospital development plan. It's in the pipeline. In the years to come, our capital works expenditure will exceed $100 billion per year. When you look at public and private projects as a whole, the construction industry will see $300 billion of projects per year. All that will improve people's quality of life and create stronger impetus for growth. And because of that, we need to make sure projects are delivered on time so that the community can share in the results of development. This will mean stakeholders such as the government, contractors, subcontractors, and suppliers need to get involved. Construction workers should also get paid for the work they do. This is to boost morale. And only then can we get young people to join the construction industry. Otherwise, with more wage arrears, young people will not want to join the sector. A single construction project can involve 5 stakeholders. You can have different layers of subcontractors. Take a school. Under a main contractor, there are several subcontractors for investigation, piling, etc. And then the subcontractors procure materials. At each stage, many workers are involved. The main contractor takes on both public and private contracts. When there are fewer projects, or when cash flow becomes an issue with one project, then contractors run into cash flow problems, and then the smaller subcontractors and workers suffer. Payment disputes are commonplace. In 2011, the government worked with the Construction Industry Council on a survey about payment in the construction sector. That survey covered construction companies, consultancies, suppliers of materials and equipment. Back then, it was found that the amount in arrears exceeded $20 billion. The main contractors were hit hard, and the amount reached $9.9 billion. That's 12% of their annual receipt. 10 years ago, the then Secretary for Development, Mr. Paul Chen, wanted to amend the law. Over the years, we have now come to this stage with this bill. This bill is well intended, but we have to ensure fairness. It's justified, it's impartial. We have to be careful about the details. so that we can avoid disputes, things that can undermine harmony. To make the implementation of the bill a success, here are a few things I have in mind. First, we have to get the adjudication right. This must be impartial. Within 55 working days, an adjudicator has to make a determination. When a claim comes along, the paying party has to pay within 60 days. 60 days plus another 55 days, that's 4 months. How can workers be expected to put food on the table when they have to wait 4 months? We want to see greater efficiency since we have this bill. So I call on the government to keep following up after the bill's passage to see whether we can shorten the time frame for adjudication. The construction sector also worries that consultants and subcontractors may give you substandard work or materials, but then they abuse the process by starting adjudications. When that is the case, the adjudicator must make an impartial ruling. The bill will cover contracts with a sum over $5 million. The government said smaller contracts would not be affected to make life easier for for owners. This will actually make the law more complex. The bill is supposed to protect SMEs to make sure they get paid on time. So I call on the government to take other measures to deal with payment arrears, payment delays for these SMEs.
Dr. So Chang-Wing. President, default in payment of contract amount and wages is rather common in the construction industry. We've seen no improvement in the past decade. This year we have seen the situation worsening. Labor union did a survey in the first 11 months of this year. There's been wages in arrears to the tune of $300 million. And that's a new record in 40 years. Well, that's because there's a poor property market and poor economy, and that's why this happened. We want to tackle wages in arrears. So therefore, the government is introducing a bill to make a new arrangement for construction payment. For example, the paying party must make payment within a specified period to the claiming party, and then there is an education mechanism for speedy resolution of disputes. Also, the paying party will be given a right to stop works. Now, there's been a wide-ranging consultation to take on the views of the reference sectors, and so this bill has sufficient deterrent effect. For example, when a subcontractor is owed payment, they must still complete the works in accordance with the contract. With this bill, then the claiming party may slow the progress of work or even stop the works as a way to put pressure on the paying party to pay up. So I believe this bill will be able to protect the rightful interests of referent parties and promote the healthy development of the industry. So I support the Construction Industry Security of Payment Bill. But then I would like to express my concerns and also make some suggestions. First of all, for payment delays, I support adopting a zero-tolerance attitude. Now, this is poor practice in the industry. There are various reasons. So the pressure on cash flow is passed on to down the different layers of subcontracting. And then some subcontractors may deliberately delay payment. this year we've seen the worsening of the situation is because many businesses up the industry chain have experienced financial difficulties. Now, there are major companies that have collapsed, and that's sparked a vicious circle of delay in payment. The bill will impose positive pressure on contractors, subcontractors, but then it may also lead to it may speed up the winding up of companies. So the government needs to take into account the economic situation. Now, where there are genuine difficulties, the government should give assistance. Otherwise, we'll see more contractors and subcontractors collapsing, and that will spark a domino effect. So that will not benefit the reference projects, the workers, and the industry as a whole. So this bill is supposed to offer a solution, but it doesn't really tackle the issue at root. The bill does not address the two root causes of the situation. One, the lowest bid wins situation and the multiple layer of subcontracting are real issues. So the government is not trying to tackle these issues at source. Right now, the construction industry still allows still accepts lowest bids. So there's cutthroat price cutting among tenderers, and that's a key reason for delay in payment. Multiple layer of subcontracting is also common because works project covers many different specialties, so we cannot have just one contractor carrying that work. That's why there are often subcontracting or subcontracting and so on. And if the one party along this chain delays payment, there will be knock-on effect on the other subcontractors. And then the government does not allow the government could limit the layers of subcontracting. I believe the government could first observe how the ordinance works after it's commenced. If the ordinance is not able to stop the aggravation of the payment delay, then it should tackle the issues at source and come up with some solutions. Another point. Now, the bill only covers the delay of payments among the parties to contract. As for wages in arrear, that's still regulated by the employment ordinance, and this bill does not deal with the issue, because the government's logic is that if a subcontractor receives payment, then naturally there will be a lower chance of the subcontractor defaulting on wage payment. While this may seem logical on the surface, but really it does not offer a solution by bundling the delay of payment and delay of wages as a single issue. Now we see that the construction sector is now having a tough time, and if the bill becomes law and still it doesn't help with wages in arrear, then the government needs to consider other solutions. Otherwise, the bill will be rendered useless. So I speak. Ms. Adrian Ho. Thank you, President. In the past few years, we've seen many cases of wages in arrear in the construction industry. The relevant the Construction Association found that there are $300 million of wages in arrear involving some 2,000 workers. And then for the free one-ways project, the VRS system, it seems that the fourth layer of subcontractor had the contract terminated by the third layer of subcontractor, and then there were wages in arrear to the tune of $10 million, and the workers remained unpaid. Now, for most construction projects in Hong Kong, they are carried out through subcontracting. And then we have the owners, the contractors, the subcontractors, suppliers, and workers. These are all the stakeholders along the supply chain. And this then this chain is interlinked. So if there is delay in payment by any one party, there could be a domino effect. And in the worst case scenario, the cash flow of each layer of the contractor will be affected. So that's why I support this bill. I believe this bill will be effective in changing the contract payment mechanism, and there will be certain protection given to the parties concerned. I agree the Bureau has given comprehensive consideration to the bill. It has also made reference to similar security of payment ordinance in other countries. At the same time, the Bureau has considered the issues faced by the local construction industry and also some of the practices that have been around for ages. Now, there's been consultation and views were expressed by stakeholders on the legal framework. Now, the bill will ban the unfair payment clause of pay when paid. So this clause can no longer be included in a contract. And then I believe that will help to offer protection to stakeholders so their legitimate interests are protected. And then perhaps workers will benefit, and even the development industry will benefit as a result. Now, the bill proposes an independent and fair adjudication mechanism. Claiming party has the right to decide whether to initiate adjudication to resolve payment disputes in the construction industry. The adjudication mechanism covers a comprehensive scope. For example, laws arising from delay of payment and so on is all covered. And if a paying party admits an amount that's due, and if an adjudicator has made a determination on a dispute, and then the paying party does not settle the payment in full within the specified time frame, then the claiming party has the right to suspend or slow down the progress of works. I believe this measure will also help to protect the rights of the party being owed a payment. It could also exert pressure on the paying party. In fact, in the next few years, we will be seeing a number of mega projects. For example, the Northern Metropolis project, the Hong Shui Kiu Station project, and other MTR line extension projects. Now, the government is the biggest owner and paying party. So I hope after the passage of the bill, the SL government will serve as role model. That's important. Now, I have recently suggested that the SL government should set up a sports adjudication system that's fair and transparent. This will provide an independent platform for relevant parties to resolve the dispute. So now here, I hope we will have enough adjudicators to handle the cases. Now, adjudicators in this case must be familiar with the operation of the construction industry. They must also have the relevant qualifications to deal with work disputes. there must be proper mechanism for assessing the qualifications of adjudicators. They must make sure that there is no hidden interest involved. We must make sure that the education mechanism is fair. And then there could be effective resolution of payment disputes in the construction industry. So I speak.
Mr. Rincon, President, I speak in support of the Construction Industry Security of Payment Bill. In Hong Kong, we have many works undertaken. We have multi-story buildings in prevalence in Hong Kong. So in general, we have construction costs that are quite significant. With security of payment, it is going to be of utmost importance for the development, a healthy development of the industry. The bill comes late. The consultation started as early as 2012, so it has been 12 years. In other advanced economies, for example, the UK is leading in the area. As early as 1996, they put in place relevant legislation. In New South Wales, in Australia, they had legislation in 1999. And in Singapore, they put in place relevant legislation in 2005. These places have now had second generation legislation, so we are definitely lagging behind. The bill will resolve deep-rooted issues of delay payment in the construction industry. It will help offer protection to workers. Workers, they have paid, they have worked, and they may even pay with their lives, unfortunately. We often see news reports. In fact, I saw a recent news report that a worker was owed $400,000 odd in wages on Tong Chau Street, and he was sitting at the ledge of the building. And we have seen in many cases, many subcontractors are not getting paid. And the owners of the subcontractors had to sell their own property to pay workers. I have seen extreme examples where projects have been completed for several years. The subcontractors had yet to be paid still. I think the bill is pretty good, but then unfortunately, we do not see the bill covering large-scale maintenance works in private residential buildings. I think we should not neglect the scope of these buildings. In fact, the government allocated over $19 billion for various maintenance subsidy schemes for buildings. It does not even cover the maintenance works paid for by owners of these buildings. While the government did explain they have consulted the industry and has struck a balance between different interests, I find this to be inadequate. If these works are not included under the scope of the bill, some subcontractors may not be willing to undertake such works. Or maybe they would include a risk premium in the prices, so that would make the high prices even higher for maintenance works, causing a huge burden on owners. We have been encouraging owners to undertake building repairs. We have also increased the penalties. But then with the provisions of the bill, it may increase the prices of works. Owners may be affected in the end. We have owners who do not have much bargaining power in such works. They should be offered more protection. They are not covered under the bill. thus there is inadequate protection for them. I urge the government, upon passage of the bill, to review the implementation of the bill to see if there is any room for improvement and cover such works. I so submit, President. Mr. Look Chung Hong. President, I speak in support of the construction industry security of payment bill. With our history, we have all along been adopting subcontracting in the construction industry with various professionals' involvement. We need good collaboration. The key to that is to have a healthy cash flow circulation. We have seen waves of wage arrears in recent years. And as someone who works with labor unions, I would often ask if it is the case that the subcontractors are owing you because they have their own problems, or is it the case that they are clashing with the upper tier parties and have the workers try to fight on their behalf? I think with commercial disputes, there is a better mechanism to deal with this. And I think the construction industry's security of payment bill would come in handy. It does do something about the improper practice. I think this bill comes at a right timing because we have many major developments underway, such as the Northern Metropolis. But I also think that this has come very late. The Development Bureau in 2011 had already engaged a consulting company to research the possibility of putting in place relevant legislation. It has been a decade. In 2023, another detailed study was conducted. I understand that we did not have the right political climate to perhaps enact relevant legislation, but we should not have such a significant delay that until only today we have proper protection for workers. So this has really come late. In the construction industry, we often see this. Allow me to use a slang here. We do not have the workers who have good bargaining power. Basically, those with less bargaining power, they will be abused. They will be threatened. So how does it happen in the construction industry? So the upper tier parties would say to the lower tier parties, if you want me to settle payment, give me a discount. But there's always a justification they would provide. They would say, hey, your workers are always late. And then why are they late in the first place? Because they have to take the boat services provided by the upper tier parties, and the ferries were late, thus they were late. So the upper tier parties should not have a reason to really punish the lower tier parties for that, but then the lower tier parties had no other choice. And they had no choice but to give the upper tier parties a discount, and even a big discount. And then the other lower tier parties would then get payment to pay the workers. So this happens on various levels in the construction industry. Workers are owed wages, they need to take action, or they may suspend works. Right now, in the existing state, if they suspend works, they may be punished. With the bill's provisions, there is a right for the lower tier parties to suspend or delay the carrying out of works, and that there won't be any pay when paid clauses in contracts in future. And there is also an adjudication mechanism that should save time and costs in resolving disputes. But we have to make sure the adjudication mechanism can resolve disputes quickly and effectively. We need to follow on the implementation in future. Also, we have some subcontractors tell us that they are worried about suspension of works leading to delay in projects. I think that will not happen because I think everyone wants to complete the works as soon as possible in order to get payment. I don't think there will be a problem of the imbalance in bargaining power, and that there would be the issue of risk premium. In fact, there may be the lower tier parties may inflate the budget so as to have it discounted in future. With the bill, I believe this will not happen anymore. We will also have workers who will be paid when they have worked. It will also reduce the risk premiums involved. In turn, that will lower the costs in the construction industry. Lastly, I also note in the bill that within 30 days, a payment response has to be made, and 60 days, the payment would have to be paid. Are these appropriate numbers of days? Because 60 days seem quite long for payment to be made to workers on time. So I think with experience, we'll see if there has to be change to these parameters. We will have a better management system in the industry with this bill. And I urge the government to monitor the situation to make sure the bill is indeed resolving disputes. And we also encourage those in the industry to make provisions clear in written agreements instead of just using verbal agreements. We have large sums involved here. If we only have a contract on WhatsApp, it is not ideal. I think we need to have a more comprehensive system to offer better protection to workers and to ensure prompt payment to subcontractors and lower the construction costs. I so submit.
All right. Mr. Chen Kim-po. Thank you, President. I support the construction industry security of payment bill. This bill sets out clauses to improve payment terms, sets out an adjudication mechanism. A claiming party that is not paid upon meeting certain conditions can slow down or suspend work. The bill seeks to ensure all parties get paid on time. That seeks to address payment delays to ensure robustness of the entire supply chain. This bill seeks to address a long-standing problem of payment delays between parties. The bill will ban contractual terms that effectively mean pay when paid. A party cannot refuse to pay or delay in paying a lower tier party by saying they haven't got their own payment. This will protect the lawful rights of subcontractors and subcontractors. With a robust cash flow, workers will get paid on time. The bill also sets out an adjudication mechanism. That mechanism will provide a speedy process that provides a ruling with binding powers. In the past, it was all court procedures. With this bill, there will be this mechanism with a clear time frame. An adjudicator will have to make a determination within 55 days. This will speed things up. This will reduce the risk of the cash flow running into trouble. A paying party that fails to pay based on the payment response on time or fails to pay the amount set out in a determination, the bill gives the claiming party the right to slow down or suspend work. That's a way to pressure the paying party to settle the amount. This also encourages better management of the project and finances. This bill gives parties more flexibility and lowers the risks for businesses. Singapore, Australia, and the UK have their own construction industry security of payment laws, offering a speedy and efficient way to resolve disputes. Here, once this bill is passed, we will be able to fix the problems of wage arrears for workers. There will be better protection for payment. There will be a reduction in the risk premium. Project costs may also go down, and that may mean more contractors will get involved in projects, and this will make the industry more competitive. I support the bill. Mr. Peter Chu. Thank you, President. I speak on the construction industry security of industry bill. My family is in the construction materials business. Payment delays are a long-standing problem in the construction sector. A construction project covers a wide range of procedures, steps. No single consultant or contractor can do everything. That's why subcontracting is common. There are stakeholders, project owners, different parties, suppliers, consultants, etc. When one side delays in paying the other, there will be pressure on the finances of other parties. Small and medium businesses are particularly vulnerable, and that may mean delays in the project. And that also means wage arrears for workers. The Development Bureau hired a consultant to do surveys in 2011 and 2023. Each year, outstanding amount reached almost 5 or even up to 12% of the receipts for the stakeholders. The delays could be as long as 6 months or even 2 to 3 years. As the government said, payment delays saw no marked improvement over 10 years. Wage arrears affect more and more workers. A recent media report says a trade union found early this year there were 200 requests involving 2,000 workers. The sum involved more than $300 million, the highest in recent years. In July, more wages in arrears involving $160 million. The bill here mainly deals with contractual disputes. It's about resolving commercial disputes. But it's also about wage arrears. Once you fix the contractual dispute, the subcontractors get paid, and then they will be more likely to be able to pay the workers. The bill can also address the problem of risk premium because subcontractors worry about payment delays. With this bill, construction costs may go down. The bill will apply to projects over $5 million. The government explained that this would apply to the main contract. In a major project, $5 million is a small sum. because that sort of contract involves large sums. We adopt that sum as the limit. Even dump truck drivers and other subcontractors will be covered. Both written and oral contract will be covered. The government explained why leaving out contracts below $5 million. Doing that would be disproportionate, because that would lead to burden on people involved in smaller contracts. I find that sensible. Now, on smaller contracts for private flats, they are also out of scope. I support this direction, but we should keep an eye on this, especially for maintenance projects. Now, for private flats, their renovation projects and maintenance projects are out of scope. The government's explanation is that the owners' corporations pay the contractors. In such cases, OC meetings are needed when payments are involved. And that means OCs may struggle to meet the requirements under the adjudication process. And for renovations, they involve smaller sums. So I get the government's point. When work is suspended, residents of the private flats involved are affected. So we support the government's approach. We're leaving out building maintenance project. Many flats, many housing estates may see maintenance contracts involving over $100 million. When those contractors fail to pay their own subcontractors, that's a form of injustice. So once this bill is passed, I call on the Development Bureau to keep an eye on how things go. Once this bill is passed, there will be a 3-month window for initiating and also resolving the dispute, and that will be helpful for the sector. So the Liberal Party supports this. Mr. Dennis Leung.
President, I'm a member of the Bills Committee. I speak in support of the passage of the Construction Industry Security of Payment Bill, as well as the amendments to be moved by the Secretary. The bill applies to all procurement works projects of the government and statutory bodies. Now, this is to improve the payment terms in contracts and improve the cash flow of the various parties. Now, there are 4 requirements. There will be prohibition of contracts with certain clauses, and then there's a right for claiming party to slow down the progress of works. Now, the FTU also gave views during when views were invited, and then we asked the electrical to speed up the scrutiny of the bill. This will offer protection to workers, and then they can receive wages on time. Now, this it takes much effort for this bill to be presented. I must thank the administration for extensively consulting all the stakeholders, the contractors, the suppliers, consultants, the labor sector, and so on. So they've taken considered the views of all the stakeholders, and it's after years of discussion that we've come to a consensus. We all want to address the issue of wages in arrear at the different layers of subcontractors, because there is arrears in ages because there are so many layers of subcontracting. So I would thank all who have expressed support for prohibiting the pay when paid contract clause. This will address the payment issues with the construction industry. Now, we are going to pass the bill today, but then the bill will only commence 8 months after Gazettal, because the government needs time to work out the adjudication mechanism, such as deciding the functions of nominating bodies, formulating the codes of conduct, education rules, and so on. Now, I was involved in two industrial actions as a member of the council, because members were owed wages. They don't want to pursue their employers, but rather these main contractors, because the main contractor delayed payment. Now, there were for these two cases, one was in Tongchong, the other is the Anderson Road Housing Society construction site. Now, we know that the housing society has replaced the main contractor. Now, in the past, when the reason why there's arrears in wages, because the subcontractors are owed payment, so they cannot pay their workers, and so and then the main contractors may pay, the owner may pay for 2 months, but that's all. Now, in this case, the subcontractor that I handled, the subcontractor has tried their best to make payment to workers. The contractors borrowed money from the bank. He's even sold his property to pay workers. And so they've therefore been making payments for 3 months. For the Anderson site, some $46 million of payment was delayed. Why is it that the subcontractors did not receive payment? Is it because the housing society did not pay the main contractor? Well, it's not the case. The housing society has been paying the main contractor on time. And then sometimes they even made payment in advance to help the main contractor to improve their cash flow. But then the main contractor just never paid the subcontractor. So there's a substantial delay in works progress. Now, if this bill were already in place, I believe it would have helped these cases and help the subcontractors with the problems they face. And then there would be no delay in works progress. Now, why is it that workers have to pursue wages arrear? It's because the main contractors delay payment to subcontractors. It's because most of the works were approved during the COVID pandemic. The price was really low at the time, and with the current day price, it's not possible for the main contractor to complete the works, and that's why the main contractor would not inspect the works of the subcontractor. Or before there's work inspection, the main contractor asks the subcontractors to make payments first. I'm worried this situation will persist, and I hope the SO government will face up to the issue, because we want to build the reputation of the construction industry. We want to attract young people to join the industry, so we need to follow up on these issues properly. Now, even if the bill is passed today, we cannot fully address the issue of delay in payment. I think the construction industry needs to set up a new system. There must be a sufficient fund pool for paying the workers, so there won't be wages in arrears for workers. And then the SO government should require all parties to pay, stakeholders to pay into this fund pool. And then we can make sure that works could progress as scheduled, and then we can make sure that there is payment made and payment to workers as well. That will help to the healthy development of the industry. Now, there is already a new management approach for works. Housing authority is already doing that. For example, the main contractor will supervise and manage the work. The main contractor receives a management fee. In August this year, I visited Shenzhen, Longgong, I learned that the mainland also adopts this approach. The main contractor is both the supervisor and the manager, and if the quality of works is not up to standard, they won't get paid. They will even have to make compensation. That will help to improve standards. And then there is an 8-year warranty period to make sure that the materials used are up to standard. So I hope the SL government will further consider reforms of the construction industry to address the various issues. Now, in the past few months, frontline workers have suffered losses. I hope workers will learn to protect themselves. Even if they know subcontractor well, they must enter into written contracts to make sure their interests are protected. And then frontline workers must also learn about the provisions of the employment ordinance. That is, employers must pay wages within 7 days. After the end of a contract or after the completion of work. And if the employer does not pay wages without reasons, it's against the law, and the workers should complain to the Labor Department. Now, when I was a child, on TV, there are often ads on the construction industry. I hope the SL government will fully grasp the problems in the construction industry and address them one by one. Now, both workers and subcontractors need to be given protection, and only then there will be a healthy development of the construction industry. So I speak.
Does any other member wish to speak? If not, I now call upon the Secretary for Development to reply, then the debate will come to a close. Secretary. President, I would like to thank Dr. Loh Wai Kwok, the chairman of the Bills Committee, Mr. Chen Siu-hung, the deputy chairman, and the remaining members of the Bills Committee, the stakeholders attending the public hearing, the Electrical Secretariat, the legal advisor, colleagues from the Department of Justice, as well as colleagues from the Development Bureau for their efforts in making the scrutiny of the bill smooth. I'm also very grateful for the many members who have spoken in support of the bill and expressed their valuable views. The construction industry is an important driving force of Hong Kong's economic growth. It covers a wide range of engineering and building projects. As Dr. Loh Wai Kwok said, it involves a wide range of professions and trades. It is generally difficult for a single contractor or consultant to undertake the whole project. To increase flexibility in project procurement, subcontracting arrangements are common, and a smooth cash flow circulation is important to the stakeholders in the construction industry. However, stakeholders have faced persistent payment problems in the industry, including non-payment and delayed payment issues that has affected the operations of the supply chain. It may also lead to delays and disruptions of works projects, and in the end that would result in non-payment of wages to construction workers. It is therefore necessary to resolve the payment problem to address the issue to ensure the smooth implementation of construction projects. Indeed, as some members said, we are now bearing fruit after extensive discussions over the past decade or so. We have seen us overcoming the challenges. In May this year, the bill received its first reading in the Legislative Council to resolve this deep-rooted problem in the construction industry, to improve the operational environment of the industry, and to ensure prompt payment is received by subcontractors that will in turn reduce non-payment to workers. The bill has provisions to improve the payment terms of contracts by prohibiting the inclusion of unfair payment terms in contracts. We will also have an adjudication mechanism introduced in the bill to provide a speedy, cost-effective, and binding interim payment dispute resolution process, and provide that under specified circumstances, the two cases set out in the bill, the claiming party has the right to suspend or delay the carrying out of the works to ensure that stakeholders can receive payments as scheduled. But let me say this, there are specific cases, two cases in which the claiming party can make such, otherwise it cannot suspend or delay the carrying out of works. A, where the paying party has undertaken to make payment after a claim has been made by the claiming party but fails to make payment by the deadline, or B, where the paying party fails to pay the amount determined by the adjudication mechanism by the deadline. With this bill, we have referred to the practices in different jurisdictions, the UK, Singapore, and Australia. We have referred to their security of payment legislation, and with reference to local circumstances, we have made revisions. We have seen the Bills Committee commence operation in June, and all the way up to November 11 meetings were held. There was a public hearing, and during the deliberations of the bill, members had in-depth discussions on the legislative proposals. The Bureau is grateful to members for their support. We need to make sure, especially how the adjudication mechanism is effective and fair. Members have given us valuable feedback. After careful consideration, the government has proposed amendments to the bill in this regard. I will elaborate on the proposed amendments later. The main provisions of the bill will come into effect 8 months after date of gazettal of the ordinance. To make sure there is enough time for preparations to be made, including nominating bodies to apply to become eligible organizations, the arrangement of training courses for adjudicators, training an adequate number of educators, and the establishment of a panel of adjudicators. Industry stakeholders will also need to review and revise the terms of existing construction contracts and subcontracts to comply with requirements of the bill. During this period of time, we will also launch a series of publicity and promotional programs. In November last year, when we consulted the panel on development, the original commencement date was 12 months after gazettal. On the advice of members, we have made concerted efforts with the industry to compress the time needed for the preparatory work, and we have shortened the commencement period to 8 months. On the scope of application of the bill, when the value is lower than the minimum contract value, it will apply not only to public projects but also to private projects, construction projects, as well as contracts to supply goods or services. The scope of application will be different in public and private projects. There will be more public projects covered. Some express their views asking for large-scale maintenance works on private residential buildings to be covered by the bill. Let me say this. With maintenance works in residential buildings, if the buildings involved are managed by the Hong Kong Housing Authority or the Hong Kong Housing Society, say for the public rental housing estates, they are specified entities as Hong Kong Housing Authority and Housing Society are specified entities. Their projects will be covered by the bill. And we consider it inappropriate to cover maintenance works for private residential buildings because owners may not have adequate knowledge in the industry, and they may not be able to meet the tight deadlines in the timeline of adjudication. With this, there may be suspension of works by certain subcontractors. It may cause safety and hygiene problems. We do not wish to cause a nuisance to residents. That's why we do not plan on including the large-scale maintenance works in private residential buildings in the bill. But we have taken this issue to the task force and the relevant industry. We have asked the industry for feedback. They believe the current proposals have struck a balance between different interests, but having accumulated experience, we will conduct timely reviews of the provisions. During the deliberations of the Bills Committee, members took much time to discuss how the bill is to apply in mixed-use buildings and whether the provisions of the bill would cover the relevant works in these buildings. Indeed, the issue is quite complex. We will make sure we are formulating clear guidelines, including dummy kits and flowcharts to facilitate understanding by the industry. Sometimes it's not about subcontractors did something wrong, yet there's still a delay. So there is extension of time for works. For extension of time-related disputes, usually these are quite complex. So we believe a phased implementation will be a more prudent approach to take. So for construction contracts procured by public organizations, we will introduce the implementation of adjudication for extension of time-related disputes. Once we have accumulated experience, nominating bodies will step up training for adjudicators and communicate closely with the industry to review the effectiveness of adjudicating such disputes. When the industry is ready, the scheme or the provisions will be extended to cover payment disputes in the private sector. We have included provisions in the bill to provide for the commencement of the relevant measures by way of gazettal. Some asked how we could prevent abuse of the adjudication mechanism. The bill provides that both parties to a contract can apply for adjudication only after going through the claim handling procedure stipulated in the contract. However, if this is not included in the contract, there is also a mechanism under the bill that the adjudication process must be completed within a reasonable amount of time. Otherwise, claims can be made, or if necessary, adjudication can be requested. And we ask that when adjudicators consider the relevant evidence, they need to consider the relevant professionals such as engineers, quantity surveyors, advice. And the bill also provides that a party may give evidence, but such evidence must be made known to the other party. So essentially, one cannot ambush another party, and the adjudicator can disregard any of such evidence given in ambush. Also, the claiming party cannot submit repetitive claims. We believe these measures can effectively prevent abuse of the adjudication mechanism. Members are also concerned about what publicity and education work is to be carried out. We very much recognize the importance of this part of the work. We hope that members of the industry would have a clear understanding of the scope of the ordinance, the requirements for payment and response, the operations of the adjudication mechanism, etc., so that the ordinance can be effective. Before the ordinance comes into effect, we will work with the Construction Industry Council for publicity and education. That would include setting up a dedicated website, compiling easy-to-understand guidelines. We will also hold seminars for industry stakeholders, and we will also give them advice on amending the terms in standard contracts to make sure they can conform to the requirements under the ordinance. We will also work with the judiciary in making relevant rules on court procedures relating to the setting aside and enforcement of education determinations. We are ready for the commencement of the bill on 27th of December, President. Members' concerns about the main contents of various documents, including the education rules as well as the regulation of fees, these are all generally ready. We hope that in January 2025 we will publish the relevant documents and will start processing applications from the nominating bodies. President, I implore members to support the bill and the various amendments that I will move at the committee stage. We understand that this bill alone will not resolve every single issue in the construction industry. We have much to do in future. We will conduct timely reviews on the scope of the bill and the details of the implementation, but the passage of the bill will be a milestone, so that we can help stakeholders in the construction industry to receive prompt payment, provide better protection for them, so that the construction industry can have sustainable development.
And now put the question to you that the Construction Industry Security of Payment Bill be read the second time. With those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Construction Industry Security of Payment Bill